In this video we want to discuss the law of the European Union. The UK joined the European Union in 1973. Prior to that, the community was established in 1957 when France, Germany, Italy, Belgium, Netherlands and Luxembourg signed the Treaty of Rome. So what is now the European Union came into existence in 1957 with the Treaty of Rome, and the UK joined in 1973. The European Community now has a total of 27 members. It's always worthwhile when you do a video like this is to check what the current state is. At the time of making this video it's 27, but there are always new applicants to join, and there's always discussions on the way to bring in extra members and for the expansion of Europe. It seems to be a common theme throughout Europe that it should expand. But at the moment there are 27 members, which makes it very large. After 1973, the European law was incorporated into UK law, and this created another source of law. In the UK, historically, law was based on custom and traditions, which became known as common law, and it came through from history, from the way we live as a people. So the source of law was in traditions and in communities and in ways of living and ways of transacting. These came through in a body of law known as common law. There was a second source, which was legislative law. This is law made by Parliament, and sometimes the government makes laws. So there are two sources of law in the UK. But after 1973, the European Union, which at that time was called, I think, the European Economic Community, the EEC, but at that time their source of law and their requirements in law was incorporated into the UK system. So there were, in a sense, three sources of law after 1973, after the UK joined what is now the European Union. So the three sources were common law in the UK, legislative law in the UK, laws made by the Parliament in London covering all of the UK, and also requirements for from Europe, which was this extra source of law. The European Union is broken down into different sections. It's a very big organisation, so it should be quite obvious that it has to be broken down into different sections. The middle section consists of existing communities known as the European Community, and within this we have the European Coal and Steel Community. This has particular relevance to countries who produce a lot of coal or make a lot of steel, obviously. There's the European Atomic Energy Treaty Community, which has a wide interest right across Europe. Clearly it's in everyone's interest to try and wind back the possibility of nuclear proliferation and nuclear disasters. And we have the Economic Community. So we have different focuses within Europe, looking at different things, different issues. And when we think of Europe, we normally think of the Economic Community, but in fact there are other strings to its bow. The European Union is broken down into different sections, as I said. The external section of the European Community consists of common foreign and security policy. So try to imagine around the periphery of Europe, around the edge of Europe, there is a foreign policy. The foreign policy is how the European Union tries to deal with the rest of the world, how it deals with America, how it deals with the Far East or with Russia or with Africa. So there is a foreign policy, a stance taken by Europe on certain issues. There's also the police and judicial cooperation in criminal matters section. Criminals don't normally confine themselves to one country or respect borders in countries. Criminal activity may spread right across Europe. It may spread right across the world. So it was felt that having an agency that looked into criminal matters that was pan-European, that right across Europe, was a good idea, and that's what they put into force. So there is a high level of cooperation between police forces right throughout Europe on various issues and on various criminal activities. These sections form the Union. However, only the European Community is governed by community law. So only the European Community is governed by community law, and that's an important thing to bear in mind. It's only the countries who subscribe to the European Union, who are members of the European Union, who have incorporated it into their legal systems and have gone through all the processes of membership. Those countries will be subject to community law in the areas where the European Community have a right to make law. So there's broad agreement, for example, that, as I said earlier, that countries should cooperate in police matters. It may also be worthwhile subscribing to the European Union on foreign and security policy, because the rest of the world will listen more intently if one member speaks on behalf of 27 countries. The person speaking then is seen as very powerful. Now, the European institutions, well, there is the councils. There's the Council of Ministers. This is the main legislative body of the community, where meetings are held regarding current issues and policies. So this is where law is really brought forth. This is where suggestions and recommendations for changes in the law are discussed and debated, and eventually, if there's enough support, it'll become the law of the community. So this is where the Council of Ministers are involved. The Council comprises of representatives of member states. These representatives have the authority to stand as government for each state. So there are ministers appointed by individual governments who sit on the Council of Ministers in Europe, and the person who sits on the Council of Ministers in Europe represents that country. So it's like having all 27 countries sitting around a table making laws that cover all of them. So you can see it's a very powerful institution. The meetings are chaired by a president. The president is replaced every 6 months between heads of state. So every 6 months there's a new president. So there's going to be, after 13 and a half years, I should say, 27 members, each for 6 months. That's 13 and a half years, I think. The same president, if he was in power, the same president would chair it again. So the chances are it's once in a lifetime that an individual will chair the Council of Ministers. Political lives are not that long, generally speaking. So each country gets to be president. They're president for 6 months, after which it moves to the next country and they become the president. And they're president for 6 months as well. Then we have the European Council. The European Council was established in 1974. It's the highest political level where community leaders hold informal meetings. So this is where there are quite informal meetings discussing issues and discussing what needs to be done or what needs to be fixed, or any inconsistencies in its own internal processes or in its own legal framework. So all issues can be brought up and discussed in this context. The heads of state come together to meet twice a year to discuss community matters. So, over and above all of the institutions in Europe, the heads of state, in this case the 27 heads of state, right across Europe, will all meet twice a year to discuss any issues, anything that anyone wants to discuss. And this means that the domestic governments, the governments that subscribe to the European Union, they're well informed, and they also can make recommendations and require changes and ask for changes, which will have to be discussed all the way through the institutions of Europe, which may eventually become the law of the European Union. When heads of state meet, it's a less formal atmosphere compared to the Council of Ministers. We see them on television sometimes, and they meet in some country, and they have discussions for a few days, and they have social meetings, and they talk amongst themselves. It's a forum for the exchange of ideas and sounding each other out. How do you feel about certain issues? So it's a way of moving forward suggestions, talking to people, trying to convince them that a certain change is required and getting their support. And when it goes back to Europe, then there is more support for it in Europe. The Council of Ministers, well, this is the main legislative body of the community, where meetings are held regarding current issues and policies. The Council comprises of representatives of member states. These representatives have the authority to stand as government for each state. So each member of the Council of Ministers represents their own government, their domestic governments, represents where they came from. So there will be 27 countries all sending representatives, and those representatives will represent their own countries and will argue for policies in favour of their own countries, and will make concessions and will debate issues, and eventually law emerges from all of this that covers the European Union. The meetings are presided by a president. The president is replaced every 6 months between heads of state, as I said earlier. Now, the European Commission, well, the Commission body has the responsible role of policy making. So the European Commission is what makes European policy. The Commission is developed by nominees, one from each member state. So each member state puts forward a person to speak on their behalf. You can see how complex this is, because clearly some countries are big and powerful and some countries are very small and perhaps quite weak. But if each one has one say, then there could be issues. You could say it raises issues about democracy. Should not the person who represents the big population and the big country have more of a say than a small country? So there are issues to be debated, and these are constantly brought up and discussed, how to find ways round this. The major decisions made in the Council start from the Commission. The Commission is where issues are first discussed and then moved off to the Council to be enacted into law. So the Commission is where everything kicks off. The Commission sets the basis for policies and proposals. So the Commission is the first port of call. This is where ideas are first brought up and first discussed and criticised and checked and rediscussed and altered and changed and brought back, and it's the whole process of sorting out the initial issues. But once that happens, then they may move to the councils, where it will eventually become law. There's also the European Parliament. The Parliament works in accordance with the Council to consider and formalise legislation announced by the Commission. So the Commission make recommendations. Then it moves to the Parliament, and the Parliament discuss it. They debate it, and if it's approved by the Parliament, it can go off to the Council. So it's debated in various forums. It's not just discussed at the Commission level, the first level. It goes off to various venues for discussion, and it could be considered by the Council simultaneously with the Parliament, although they will not make recommendations at that stage. They're simply aware of the issues and they're preparing for their discussions. But the Parliament is one where issues will be discussed in detail. It's like any Parliament, except it's made up from 27 different countries. It's developed by 785 members. Again, it's always worth checking these figures. So if you have a chance, go online and see if it is 785. It might have gone up or might have varied somewhat between making this video and when you study it. These members are elected by people who have voting rights. So the members of Parliament are elected directly by the people of Europe, by the ordinary citizens of Europe. So there are European elections. The European Court of Justice. Well, the court consists of 25 judges and 8 advocates. The court has 2 major functions: to interpret an area of EU law referred by member states, deals with EU law that is unclear or misrepresented by other member states. Sometimes when the European Union passes a law, some states don't like it. They don't like the implications of the law, so they may take a different interpretation, in which case it'll go to the European Court of Justice for a ruling. And if they're found guilty, they'll have to change. The country can be found guilty of not fully implementing a piece of European legislation, or perhaps misinterpreting the piece of legislation. So it may be the case that that country will be referred to the European Court of Justice, and there will be a ruling in favour of the country or against the country, which of course is quite embarrassing as well. But generally speaking, that means the country has to change its procedures. It also resolves cases alleging breach of EU legal obligations. Sometimes countries don't implement the law fully, and they can be brought to the European Court of Justice. For example, let's say the European law stated that workers should only work, whatever, say 40 hours a week, and some country ignores it, and the people are working 45 hours a week. In that case, that country could be brought to the European Court of Justice, and a ruling will be handed down from the European Court of Justice, perhaps finding the country guilty. So the country has the embarrassment of being found guilty by the court, and will have to change its procedures. Now let's look at the sources of European law. Well, the primary source, the treaties. The primary element of the European law is the treaty, or the treaties, or are the treaties, I should say. It's a plural, so are the treaties. But the primary source of European law are the treaties, the various treaties that have been discussed and agreed upon by the various members. These treaties have the right to impose legal obligations on other member states. Once the treaties are agreed, then they apply to every state. There's no opt-out. So if a country disagrees but they're outvoted, then they have to come into line. They have to agree. There are documents that assist in this. For example, the Treaty of Rome specifies how the treaties should come into existence and what are the what are the powers of the treaties, and how should the treaties be enacted. There's also the Single European Act of 1986, which reinforces the whole procedure and makes sure that the treaties are seen as the ultimate source of law in Europe. There's the Maastricht Treaty, quite a famous treaty in 1992, a very controversial treaty in some respects, but it altered the way the European Union was moving. It moves it towards closer cooperation, and that's why it became so controversial. Some countries did not want closer cooperation. They wanted a looser form of agreement, perhaps economic cooperation, but without great involvement in their internal procedures. There's also the Treaty of Amsterdam in 1997, which further modified the process. And finally, the Treaty of Nice in 2003. So all of these various treaties go to reinforce the procedures within Europe, and generally speaking have brought about closer cooperation, so that it's moving more towards a single state than 27 individual states. There's more synchronization, more harmony in their legal procedures. There's more commonality between all of them now because of the influence of the European Union, and therefore they're becoming less different. And of course that's the basis for them ultimately to come together perhaps into a single state. Let's look at the treaties. The European Communities Act of 1993 states that the treaties must take effect as UK law as well as other countries. So the European Communities Act must be applied within an individual country. Let's say in the context of the UK. The European Communities Act must be implemented in the UK, and it must also be implemented in the other countries. So it applies, as I said, right throughout Europe. A few of these agreed obligations are enforced by citizens. Sometimes countries, as I said again earlier, countries drag their feet, metaphorically. Sometimes the countries, they don't completely agree, but they have to do it. Otherwise, they're not members of the European Union. Those are the rules. So they may not like the piece of legislation. They may not like the obligations that are imposed upon them. And in that case, they may not fully implement them or enforce them or even legislate to bring them into law. In which case, citizens in the country who like that piece of legislation may bring them before the European Court of Justice and may force them to implement the law. For example, under Article 141 of the Treaty of Rome, which discusses equal treatment of men and women in employment environments. So Article 141 tries to deal with discrimination on the basis of gender. Now some countries may find that very difficult to enact for cultural reasons, historic reasons, or because simply the legislature is composed entirely of males who don't see the need for any such law. It could be for all sorts of reasons. But women have said that's the law you've signed up to, and would then take the country to the European Court of Justice, get a ruling, and have the country found guilty, which is, as I said, is very embarrassing. So to avoid all of this, and to avoid them being forced into implementing it, which makes them look like very reluctant members of the European Union, to avoid all of that, they try to implement it right from the start. Another source of law is regulations. These are imposed directly on all member states. All member states must follow the regulations of the European Union. This could be in terms of agriculture or transport or imports, exports, banking systems, whatever it is. Whatever the regulation is, it applies equally to all member states. And they must be adopted by the member states within the community. They must be wholeheartedly adopted and implemented. And the regulations take effect as soon as they've been issued. As soon as the regulations have been agreed, they're implemented straight away. There are also things called directives. Now, these are relevant to all member states. A directive applies to all member states. The aim is to give rise to harmonisation of laws between member states, making the laws similar. And there are reasons, good economic reasons for this. Otherwise, some countries may make laws which are very generous to their industrial sectors, which will give them a competitive advantage, or they may discriminate against imports. It may be done on a very subtle basis, but it may happen, which again will give competitive advantage to their producers. So, to avoid all issues, the European Union tries to harmonise law. Of course, you can also see there's an underlying theme in this, that if they harmonise all the laws across Europe, between all 27 countries, eventually all the 27 countries would have the same law. And if they have the same law, then ipso facto, they are the same country. The directives set out aims which are expected to be achieved within a set time period. When a directive is issued, they give them a certain period of time to implement it. It doesn't have to be implemented immediately, but preferably it should be. But they may say it must be implemented within the next 6 months. And that gives the countries time to make the adjustments that are needed. But it must be implemented. The method of implementation is dependent on each member state, but must be implemented by national parliament. It must go back to the national parliament and be agreed by them. So we often read in the press about countries, their parliaments having to bring forward some debate or some extra session in their parliament to discuss a European directive. And then it must be agreed by the parliament and it'll go back and become the law of that country. So the changes that the Europeans wanted have been enacted in the various countries. It's harmonising laws across the different states. Decisions, well, these only concern certain member states or companies or individuals. These are quite small and probably the weaker sources of law. These decisions must be enforced and applied to particular parties involved. It may be that even a company, perhaps a large multinational company, wants to do something or wants to change some part of its production process or whatever, and there may be issues involving the local community who might be opposed to it, or competitors who are opposing it, or whatever. The European Union has to make a decision. Should it be allowed or should it not be allowed? It could be a decision about a country who wants to change some way of working. It wants to move its main port from one area to another, or it wants to change the way it implements certain pieces of legislation and wants to change the way it processes European directives or whatever. It may decide to have one session a week in Parliament to do this, and if it doesn't fit everything in, it's looking for perhaps some concession so it can take longer to implement directives. It can cover a whole range of areas. The point is that the decisions they're weaker, and they're normally agreed to if they're reasonable. The European Union's impact on English law. Well, we're mostly emphasising English law here because it's a good reference point. And English law is quite interesting, as I said earlier, because it comes from the deep past. It comes from the Middle Ages and further back. It comes from the Magna Carta. It comes from right through history, and it's been modified, and it takes up local customs and ideas and traditions, and it comes down to us in common law. There is legislative law in the UK as well, where the government, the Parliament and Westminster make law. So we have two sources, essentially. We also have local governments who can make recommendations, and it goes to the House of Parliament in London and is approved, perhaps. So you have local laws as well. So we have different sources of law. And the European Union has made an impact on English law. So it's an interesting case study in itself to see how the English legal system has accommodated the European law. The main impact has occurred in trade, industry and employment, the environment and also financial services. So the Europeans tend to make laws related to trade, industry, employment and so on, environment and financial services. And the English legal system is very robust. It's also very flexible, and it's capable of modification and change. But it's a very well thought out system, and the European requirements are then debated within Parliament, and they will be subject to legal scrutiny, and if they're acceptable, they will be incorporated into English law. I say if they're acceptable. Generally speaking, the Europeans expect everything to be implemented, but there are processes whereby the government in London may go back to the European Union and point out there are certain issues here which have not been considered, or there are issues which our representatives in Europe at the time when this was debated in Europe mentioned but were voted down. And these issues are important. So they may require or ask the Europeans to think again. As the scope of European law develops and becomes stronger through new treaties, this will definitely affect English law, daily operations, politics and society. But the House of Parliament in London is one. As I said, there are 27 countries. So there is an inevitability that the House of Parliament in London will become weaker in the context of lawmaking as the European institutions become stronger. The Treaty of Amsterdam made a contribution to employment and citizens' rights as an important element of the Union. So here's an example of a way in which the European Union brings up some legislation, some ideas, and asks individual parliaments to enact this. Well, they ask them, but in fact if they don't, they in a sense would be in contempt of the European requirements. So it's a very interesting development. It's very similar to America, where there are 50 states, which really we could consider to be 50 countries. And they all have their own legal systems, and they all have their own parliaments, each of the states in America. But they're subject to the main legislative institutions of America, the House of Representatives and the Senate, and of course the President. But they all have to work within that. And it's very similar what's happening in Europe. we can envisage perhaps in the future that individual parliaments will be making laws which apply within certain jurisdictions, but the main laws of the country will be made by the European system. We can envisage an American type system coming into existence. The treaty I mentioned of Amsterdam also tries to improve the security of systems, of citizens, I should say, personal data, work together with member states to take action on terrorism, looks at child abuse, drug trafficking, corruption and fraud, and racism. Now, the reason why I mentioned all of this is because we can see here that the European Union is progressively getting more involved in a sense, micro issues, the smaller issues that we consider to have our own processes, our own ways of doing it. But the European Union want to standardize this across Europe. Maybe for very good reasons, because people who engage in this type of criminal activity do not normally confine themselves within one country. So perhaps there are benefits in terms of fighting crime right across Europe for having this type of treaty. But we can see how it impacts on the power of an individual state to make its own laws. So progressively we're moving towards one pan-European law creation mechanism. We're moving towards the European Parliament, the Council of Ministers. We're moving towards a European presidency perhaps, and the laws there will apply equally throughout Europe. And individual states will have individual parliaments which will make local laws that apply to their own countries. That seems to be the direction in which this discussion is going. So what we've got from this particular talk is a backdrop on the type of sophistication that's emerging in Europe in terms of law and legal requirements for membership of the European Union. We see that there are reasons why the Europeans want this. You can also see the concerns of individual states to resist it because they're losing their freedom and perhaps losing the sensitivity that the legal system had towards their own cultures and own traditions. But it seems to be an inexorable process. It seems to be one which is happening and developing almost on a daily basis. And the only parallel we can imagine that is similar to it is that of the American system. Other countries throughout the world are contemplating similar type arrangements. For example, the Association of Southeast Asian Nations, ASEAN, and some other countries, the North American Free Trade Area, for example, will have commonality in some areas of law related to trade between Mexico, Canada and the United States. But the European system by far is the most sophisticated and the most embracive. It has institutions which support what it's trying to do. It has a certain logic, in terms, I say a certain logic, because it's still being ironed out in a sense. The precise boundaries of each one is still being tweaked. But it has institutions that are focused on certain issues. It's moving towards more universal suffrage, moving towards has direct elections to the European Parliament, but the power of the European Parliament has yet to be increased significantly to enable it to take on recommendations for law and just, in a sense, run through the law and become the main centre for law making in Europe. It's got its own currency, the euro, which cuts across all of Europe just about now. There are some countries who are still outside. The main one we can think of is the United Kingdom. The UK still has the pound, but the European Union has the euro, which has become a major international currency. So the forces are there. This is the backdrop on how the European Union works. This is all I'm going to deal with in this session, so let's leave it at that and say thank you for watching.